In the Lopez-Torres case is a challenge to the New York State system for nominating one particular category of judges who are elected in New York, which is the Supreme Court judges, which, as probably a lot of you know, is the main trial court, not the appellate court. And they've been elected for a long, long time, and since the 1920s, they've had a particular system for nominating people that every single party in New York that wants to nominate a candidate for that position has to follow. It was designed at the time Tammany Hall basically ran the state, and at least those of us who are on the plaintiff side would say this is basically an attempt to have the appearance of democracy while allowing the county party leaders in each county to basically nominate the candidates unilaterally. And that's certainly how it's worked out in practice. It's essentially undisputed that in reality what happens is the county party leader just picks his friends and they get nominated for Supreme Court judge. The system is a very intricate system involving the judicial conventions which meet for one single purpose, which is to nominate candidates for that party's candidates for that particular category of judge. The delegates of those conventions have to be elected in primary elections earlier in the election year. People have to run for the office of judicial delegate, which has only one function, which is to show up at that one convention. And there's a very large number of these delegates that have to be elected in each judicial district, and they have to come from each little assembly district within each judicial district, and there's a really high number of petition signatures each person has to get. And then when they show up on the ballot, there's no way that anybody could identify who that delegate is or who they are supporting for judgeship. So effectively what this means is it's impossible for any insurgent who doesn't have the support of the county party leader but wants to run for judge to gather up a lot of friends, get them all to run for the office of judicial delegate, get enough signatures, get them all on the ballot, and then somehow educate people in each of those separate assembly districts about which delegates to vote for if they want that insurgent candidate to be nominated for judge. So the fact is, for 80 years, there have been no insurgents nominated for judgeship in the state of New York, in Republican parts of the state and Democratic parts of the state. There is effectively nomination by the county party leaders, not elected officials, but party leaders. And in most parts of the state of New York, that's effectively the same as appointing them judges, because you have a lot of parts of the state where one party or the other dominates. It was held unconstitutional in the Federal District Court in New York and in the Second Circuit, affirmed unanimously, the argument being that this effectively prevents voters and candidates from associating with each other, having the opportunity to have that democratic process operate. In the Supreme Court, there's been a kind of a somewhat different argument made that these laws basically intervene in the affairs of each political party, essentially guaranteeing that the party leaders will dominate and that the rank and file has no role to play in the most important things the party does, which is nominate candidates. The response from the state and from interestingly enough, the party leaders all support the other side, and so the Democratic and Republican parties of New York are on the other side. They all say that the statute is designed to set up a kind of a convention system where you have not democracy in the usual sense, but a deliberative process where the delegates come together with no preconceived ideas of who they're going to nominate, and they all get together and decide. And so there's nothing wrong with having a convention system of that sort where there's no real way for the people, the rank and file, to have much input either before the convention or after the convention. The notion that there's a lot of deliberation is a myth. It certainly could happen that way, but most of these conventions last less than 15 minutes, in fact. So, so interesting to see whether the Supreme Court, where they go on that case as well. The fact that they granted cert suggests they obviously have some concerns with where the Second Circuit decided the case, but maybe we will persuade them that they should not be concerned. We'll find out next.